Welcome to The Explainer. Today, we're diving straight into one of the most consequential, intensely debated, and honestly life-altering corners of the Code of Criminal Procedure in Pakistan. We're talking about Section 497. We're going to break down exactly how bail works when the stakes are literally at their absolute highest. But first, I want you to picture a pretty jarring reality. Imagine someone gets arrested, okay? No trial has happened yet. No judge or jury has actually reached a verdict. And yet that person might sit in a jail cell for months, sometimes even years, before a single witness is ever examined in court. So you really have to ask yourself, how is it possible that bail can be refused before trial even happens?
It's wild, right? And it perfectly captures the core tension in our criminal justice system. On paper, we've got this golden rule: you are innocent until proven guilty. But right up against that, we have the incredibly harsh practical reality of pretrial detention. How do we balance a person's fundamental liberty with the state's very real need to secure someone who's accused of a serious crime? Well, the answer lies in the legal mechanism we're about to unpack.
All right, let's dive into this. Here is our roadmap for today. First, bailable versus non-bailable offenses. Second, the 10-year rule. Third, assessing reasonable grounds. Fourth, humanitarian exceptions. Fifth, procedure and undue delay. And finally, cancellation of bail. Let's get right into it. Okay, Section 1, bailable versus non-bailable. To really make sense of Section 497, we have to lay the groundwork. The entire criminal code basically sits inside a two-tier system of offenses, and these are neatly listed out in Pakistan's second schedule. On one side, we've got bailable offenses. These are generally your less serious charges, things like minor property disputes or simple hurt. In these cases, bail is an automatic right. The court or the police literally must release you. But on the other side, we have non-bailable offenses. These are the heavy hitters: murder, robbery, massive fraud. Here, bail is definitely not an automatic right. It becomes a matter of judicial discretion. So the absolute most crucial point here is that if a lawyer walks into court and misjudges which category their client falls into, they've completely misjudged their entire strategy for release. And here is the single biggest myth I want to bust right now. Non-bailable does not mean no bail. It definitely doesn't mean getting out is impossible. It simply means the court has to be actively persuaded to let you out. Remember, it's discretionary. It's not automatic. Moving on to Section 2, the 10-year rule. So, knowing we've got to persuade the judge in a non-bailable case, you might be wondering just how restricted is their discretion? Well, let's look directly at Section 497, subsection 1. It says a person accused of a non-bailable offense may be released on bail, but he shall not be so released if there appear reasonable grounds for believing that he has been guilty of an offense punishable with death or imprisonment for life or imprisonment for 10 years. Now, this language, it's an absolute game changer. It basically takes this massive category of non-bailable offenses and chops it into two very distinct subcategories, all based on the punishment. And honestly, it all boils down to one specific number: 10. The 10-year punishment threshold is the critical hinge of this entire law. If a non-bailable offense carries a punishment of less than 10 years, the judge has way broader discretion to grant bail. But if it hits that 10 years life or the death penalty, which is known as the prohibitory clause, that discretion gets heavily, heavily restricted. All right, Section 3, assessing reasonable grounds. So if a charge crosses that 10-year mark, how in the world does a judge figure out guilt when a trial hasn't even happened yet? This is absolutely vital to understand. Reasonable grounds does not mean proof beyond reasonable doubt. That super high standard is strictly reserved for the actual trial at the very end of the whole process. At the bail stage, the court is just conducting a tentative assessment. They're just taking a broad look at the record to see, hey, is there solid material connecting the accused to this crime, or is the case totally full of holes? Judges are basically on the hunt for major red flags in the prosecution's story. They're asking things like, was there some weird, unexplained delay in lodging the first information report? Is there a hint of mollified intent, like false implication? Were the police recoveries done without any independent witnesses? Are there just glaring inconsistencies in what people are saying? Because if a judge spots these gaps, the prosecution's case suddenly looks exceptionally thin on its face. And when a case is thin like that, it triggers Section 497, subsection 2. If those red flags are flying, it officially becomes a case requiring sufficient grounds for further inquiry into his guilt. That right there is the magic phrase. If a court decides the case needs further inquiry because it just looks doubtful from the jump, they can grant bail. Yes, even for those massive 10-year prohibitory offenses we just talked about.
Section 4. Humanitarian exceptions. Now, we've gone over the strict legal formulas, but the law isn't totally devoid of compassion. Tucked away in a proviso to the section, the law actually gives immense weight to 3 specific groups: minors under the age of 16, women, and individuals who are severely sick or infirm. Now, just to be crystal clear, release for these groups still isn't automatic. It's still discretionary. But courts are legally directed to weight these factors incredibly heavily, simply because throwing a minor, a woman, or a desperately ill person into a pretrial jail cell is seen as disproportionately harsh. A good defense lawyer is absolutely going to invoke this proviso if it applies. Which brings us to Section 5, Procedure and Undue Delay. So we know the rules, but where does this battle actually take place? Well, you don't just march right into the Supreme Court on day 1. You start at Step 1, the trial or sessions court. If they turn you down, you escalate to Step 2, the high court. And occasionally, you take it all the way to Step 3, the Supreme Court. And at every single one of those levels, the judges are asking the exact same questions. Does that 10-year prohibitory clause apply? Are there reasonable grounds? Does this whole thing need further inquiry? But there's one massive independent factor that can just cut right through all of that: the delay rule. The courts take the phrase "justice delayed is justice denied" extremely literally here. If a trial is just dragging on and on for an unduly long time, and, this is key, it's absolutely not the fault of the accused person, that prolonged incarceration itself becomes a standalone, decisive ground to win bail. Real quick, before we keep going, I just want to make sure our terminology is totally straight. Everything we've been unpacking today under Section 497 is post-arrest bail, meaning you are already in custody and you want out. Definitely do not confuse this with anticipatory or pre-arrest bail. That's handled under Section 498, and it's designed to protect a person from being arrested in the first place. So 2 completely different sections, 2 very different mechanisms. And finally, Section 6, cancellation of bail. Okay, so what if you actually win? You get bail, you walk right out of jail. Are you totally in the clear? Well, not exactly. Under Section 497, subsection 5, the court can actually take it right back if you misuse your newfound liberty. We're talking about tampering with evidence, threatening the witnesses testifying against you, going on the run, or violating any specific conditions the judge laid down. And this is crucial. Courts do not just cancel bail because the prosecution is grumpy they lost the hearing. They will only revoke it for a genuine, proven obstruction of the justice process. So, pulling the whole shebang together, Section 497, it's not a brick wall. It's way more like a carefully designed filter. When you combine the 10-year rule, the tentative assessment of reasonable grounds, the allowance for further inquiry, those humanitarian carve-outs, and the strict rules on trial delay, you see that the law is specifically designed to filter out who genuinely needs to be locked up before trial and who really doesn't. I'm going to leave you with this ultimate thought-provoking maxim. It pretty much underpins all of Pakistani criminal jurisprudence. Bail is the rule, jail is the exception. When a single individual's liberty goes up against the massive power of the state, this is the guiding light for the courts. Think about it. How well do you feel that balance is maintained today? Thank you so much for hanging out with me on this explainer. If you found this deep dive valuable, definitely hit that subscribe button and let us know down in the comments if you want us to tackle anticipatory bail under Section 498 next. See you next time.